Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Saurav Vishnavakt, Associate Professor of Law at the Texas A&M University. My guest today is Sarah Wasserman Rajec, Associate Professor of Law at the College of William and Mary. We'll be discussing her new article, The Property Law Misfit in Patent Law. Sarah, welcome to the podcast.
Thanks so much for having me, Saurav.
Great. So let's begin at the beginning with the problem of analogy that's really at the heart of the paper. So in your view, is patent law best understood as a subfield of property law that has simply diverged from other subfields like real property, and our mistake is to hold too tightly to outmoded connections? Or is patent law better understood as a distinct field, and any connections that it may have to the domains of property law may or may not be best evaluated on their own terms?
So I think it fairly clearly is part of the property law world. I think there's sort of a long and rich scholarly conversation about whether intellectual property is property, and if so, sort of in what ways and what does that mean. And so I'm sort of continuing that conversation. I think there's sort of a strong version of the IP as private property argument, and that likens patent law, for example, to personal property or to real property and land. And so that's sort of one side of it. And as it's been used in patent law, that argument has often been used to advocate for really strong patent rights. And I think that the other part of the argument, or the other side of the argument, is that it's one form of property, and the forms include sort of private property, sure, but also monopolies, public franchises, water rights, and other regulatory grants. And to the extent that patents are like that, there's room to imagine different contours, and we have the things we want to do with it, so we can figure out how to do those. And in that way, sometimes the fact that patents are like property doesn't really answer the most difficult questions for us.
Yeah, so let me touch on for a moment the point you raised about justifying strong property rights, because that I think is one of the most important normative lessons of your paper. So we can imagine strong patent rights deriving from this property-centric view as taking on several dimensions. It could be that strong patent rights mean patents of very broad scope, or it could mean remedies that are quite robust and even aggressive at times. And then the questions of validity: what kinds of administrative or institutional protections should patents qua property enjoy? So when you say, when you sort of conceive of strong patent rights in this normative way, are you thinking of one or more of those, of all of those dimensions? What are your thoughts?
Yeah, so in the paper, I sort of trace three different areas where these strong patents as property rights type arguments have been made and shot down by the court. And it isn't always shot down, but in these cases it was. And so I wanted to look a bit at, what can we take, when is the court most likely to sort of ignore that argument, and we can argue about how much it actually hews to what property rights are, and property theory is advanced in its own way, but I'm kind of talking about property rights as they're argued in patent law. And I really think we started to see this with the 2006 case of eBay versus Merck Exchange. And so in that case, the Supreme Court looked at permanent injunctions following a finding of patent infringement, and said that there was no patent exceptionalism. You still had to weigh these four factors to decide if an injunction was appropriate in patent law. But the actual effect of the case was to give cover to the denial of injunctions in certain instances. And the Kennedy concurrence in that case, Justice Kennedy's concurrence, has really sort of held the day, or won the day in terms of when it is that injunctions will be denied. And he talked about certain situations in which injunctions might not be appropriate because they differ from historical and typical cases of patent infringement. He talked about cases where you have overbroad patents of dubious validity. He talked about having overlapping patents, many overlapping patents on one good, so that there's a potential for holdup. And I think he sort of raised these concerns that then, as we get into talking about this misfit that we'll talk about, I think that they really play into the misfit. They arise when that misfit is the strongest. So I think eBay was the first one there, where a lot of sort of patents as property rights proponents said, look, a patent is a right to exclude, and so the only remedy that is appropriate, or almost always appropriate when there is an infringement, is an injunction against further intrusion. And so, I mean, you can justify eBay in terms of property too, and I think for all of these, there are ways that you can use property law to read in limitations. But I think there the court was willing to sort of look at what's actually happening with patent infringement cases and the cases that were being brought, many of them by patent assertion entities, non-practicing entities, trolls, whatever the nomenclature is, and look at what's really happening and how it might not be furthering patent law purposes, rather than looking at sort of property law itself. So moving on, there's exhaustion, and the Supreme Court's taken up exhaustion sort of a number of times since 2008, when they decided LG Electronics versus Quanta, and then in 2013 there was Bowman versus Monsanto, and in 2017 Impression Products versus Lexmark, and all of those cases, are sort of very property related, because they're about people who have bought goods that are subject to patents and what they can do with them once they've bought them. What are legitimate restraints on alienation of those goods, and what are not. And so there, as I think about the sort of misfit of patent law to our traditional property law, I see very strongly the interests of third parties in their own property, like actual property. And so I think that that's sort of a rich one to look at. The most recent one, and you mentioned this, is administrative review of granted patents, the 2018 case of Oil States Energy Services versus Greens Energy Group. And there the court is looking at administrative post-grant review of rights that have been granted. And I think there we found sort of the most strident language, I might say, by property rights proponents. The quote from former Chief Judge Rader that these reviews are like patent death squads or property rights death squads, that make it seem like reviewing a granted patent by an administrative agency is somehow killing property rights. And again, the Supreme Court, wasn't swayed by that, and the similar language that was used in a lot of the amicus briefs that argued against post-grant review, and was looking to other things. And so I kind of wanted to look at all of these cases and say, is there something about patents that's different in a way that we can predict or explain when it is that the court's likely to do something different, and when it is that we might want the court to do something different and look a little bit deeper.
Right. So the examples you identify, right, of remedies and exhaustion and post-grant review, it seems like the thread that ties them together is really the sort of purposes to which we want patent law to be oriented. And I take from your article that the greater the misfit, the greater the potential for divergence from those values in those situations is where the courts, particularly the Supreme Court, will be most likely to say, okay, patent law is at the end of the day its own thing, and property can only take us so far. So we should allow the distinct, sort of normative purposes of patent law to prevail. Is that fair?
Yeah, I think that's right. I think that's the thread through all of those.
So then let's talk a little bit about what those purposes of patent law are. Right? There sort of two main strands in the literature. One is much more historically focused and has to do with personhood and moral rights and natural rights. But the modern conception of patents is primarily instrumental. It's much more focused on innovation. So, for your purposes, what is it about the innovation focused purposes of patent law that these misfits really sort of arise in?
Yeah, so I think that's right. I look at the innovation innovation side of it, and I think that the property law, the sort of real property or personal property analogies, can feel helpful in explaining why we would want to have patents and why we'd want to protect them. We want people to invest, and we want them to invest efficiently. And so just like we think people will put their land to the best use if they're allowed to sort of reap whatever rewards come from it, I think we sort of feel that people are best able to value their own ideas, and they can decide how much to invest in them, and will make relatively efficient decisions about how much to invest in them, and sort of get them out if the way they get rewarded is by doing that, by investing in it and bringing it to market or licensing it or what have you. So I think, I mean, to start with, the property analogy is useful and helpful, and I think there's other things about patent rights that are sort of property like. So, I mean, the main one, of course, is that they are exclusive rights. That's how they're defined in the Constitution. And that's the only thing, that's the only stick in that bundle of rights, is that it's the right to exclude others from making, using, selling, offering to sell, or importing the goods into the United States. And so, Thomas Merrill has said that exclusion is the sine qua non of property. And so here we have just an exclusive right. And so it sort of follows that patents ought to be looked at as property. But at the same time, there are ways that patents really do differ from property law. And so some of these are things that have been written about. And like I said, this is a rich literature that I decided to engage with, and sort of closed my eyes and jumped in, because a lot of sort of giants have written in this field. But so there's a number of critiques of the property law framework, and among them are that there's notice failure in patent law, and boundary ambiguity, right? So the fact that in property law, for example, if I walk down the street and there is a car sitting there, if I know it's not mine, I can be pretty sure that it's somebody else's and that I can't use it. And so the car itself gives me notice, that thing itself gives me notice that I can't use it. But then in patent law, we have all sorts of things that have entered the public domain, and we want them to be in the public domain. We have a term limit on patent rights because we want those ideas to be free to everyone 20 years after the patent's been filed. And we don't allow patents on obvious improvements over the prior art, because we think that just belongs in the public domain. So unlike private property law and real property law, we don't sort of expect everything to be owned. And I'm setting aside, public land and things like that, because that's, first of all, a fairly small minority of things. And we set up demarcations for that, and people know about parks and things like that. But normally, if you come across a piece of land that doesn't say it's a park, you probably shouldn't enter it if it doesn't appear to be public land. But with patents, there isn't notice like that. I mean, if I come up with my very own idea, if I independently invent something and then I build it out of my own materials that I own, I could still be infringing somebody else's patent rights. Mm-hmm. And so that's a real difference between other kind of property law. And so I wanted to explore in particular this sort of idea of possession, this idea that patent rights might be in rem, that is, their rights in a thing, and they exclude everyone else from that thing. But the actual right is in the idea, and then the remedy is about stopping someone else from using their own property in a way that they would like to use it, which is really different from how we conceive of private property law.
Okay, so if the sort of idea uh, of an idea being the subject matter, the race of the in rem right, is what's coming into conflict with other people's uses of their own chattels or land or the subject of their property, then that sounds like property law's internal conflict for which we have doctrines of resolution, but it sounds like the bigger misfit here is that the problems that patent law raises are different in kind because the purposes of patent law are at one side, and the conflict it creates with other people's ability to use their own things, um, that's governed by a domain of property law that has sort of different values in mind. And so, is that the bigger misfit that you're trying to resolve here?
Yeah, I think that's right. I'm sort of they all kind of play together, right? This notice failure, boundary ambiguity, and importance of the public domain. Those have been spoken about, but I think they really come out when you see that we're talking about the separation between what it is, this intangible information that the patent holder has come up with and staked their claim on, and what it is that third parties want to do with goods that are in their dominion, and exercising their own property interests towards.
Okay, so this ultimately, I think, boils down to then a problem of information cost. And you talk a good bit in the paper about information cost. Are there particular kinds of like search costs or for example, title deeds in land, we have very well defined registries, and we can know the chain of title with some, confidence, some high degree of confidence. Whereas on the other side, search costs in patent law, or even though there is a registry of patents, we may not know who owns them or what they cover. What are some of the information costs that you think are most likely to lead to the kinds of misfits that will do damage?
Yeah, so I think so. Clarissa Long has written about the information costs in intellectual property law generally, and one of the things that she talks about is that even if what you discover is that you're free to go ahead and do whatever it is you want to do, make whatever widget or invention you want to make, you still incur those information costs to do the search and to come to that decision that you're not infringing any relevant patents. And even if you decide that, right, then there's still a risk that you'll be sued and you'll still have to defend yourself, and there's still a risk that you'll be wrong too. So I think the sort of uncertainty about boundaries is much higher in patent law than it is with land. And now that's not to say there's no uncertainty with land. I wouldn't say that at all, but I think they're greater sort of in scope, and then also for other reasons different in kind. But I think they're greater in scope because we have a problem with a lot of patents that have been granted in a few different fields, and I think the courts and the PTO are trying to clean things up so that people understand what the scope of rights are in different fields, and what the validity looks like. But I think that there's still work to be done there. I mean, I'm not going to sign on to all the 101 jurisprudence necessarily, but I think that that's the point of it, right? The idea is that we have a lot of uncertainty here about what can be patented, and we don't want that uncertainty to chill other people's actions. So if patents really shouldn't be granted for certain things, or if the scope should be clearer and narrower, then we'd like to clean that up. And I think that's one of the whole points of the America Invents Act and the post-grant review expansions that we've seen at the PTO, is the idea that we should be clearing up these boundaries and trying to make it so that there's less uncertainty for, for both rights holders in terms of what it is they have, and then for third parties in terms of what it is they can do.
Yeah, I think that I would agree that Section 101, the question of what is patent eligible subject matter in the first place, really is a good illustration of the problems we face, because the number of times that prevailing understanding of patent eligible subject matter doctrine has changed just in the last, say, 20 years. There have been, a group of now 4 Supreme Court decisions. The Federal Circuit has tried with varying success to try and reconcile those precedents and generate its own ideas about what the right answer should be. But that uncertainty alone sort of highlights that no matter how well we try to make future patents that the patent office issues of higher quality, we're still going to be living in a world that's populated with, the holdovers, the patents that were issued in a sort of tougher, more primitive time, and they reflect an understanding of Section 101 and for that matter of all the other requirements for patentability that are just no longer appropriate or valid. And so, what do we do with all the stuff that we still have to live with? It seems like that's really what causes the information cost problems to arise, and what these institutional reforms like post grant review are trying to solve.
I think that's absolutely right. I mean, we can talk about how successful those have been, because I know you teach it and I teach patent law, and I don't think that the patentable subject matter area is the easiest doctrinally to sort of get through in class. But at the same time, I think that's what this has been aimed at, and what many things have been aimed at. I mean, I think eBay reflects those same concerns just earlier, and I think some of the other reforms that have followed have been focused on the same thing. You're right, the patents that are out there, and they just are sort of, one can make mischief with them. They shouldn't be enforceable, but they could still, especially en masse, be asserted in ways that make mischief.
Yeah, so remedies is the question of remedies in eBay in particular. I think is tough to grapple with, because in addition to patent law, I also teach remedies, and so eBay is the one case that I teach in both courses, and it ends up, the book I used, Modern American Remedies by Douglas Laycock, Professor Laycock's book. He just, I think he teaches about as hard against the case as it's possible to teach, while not, like just abandoning the case altogether. But the remedies scholars have taken issue with the eBay decision, not because they think the patent policy was wrong, or that Justice Kennedy, sort of missed the mark on his diagnosis of software patents and business method related patents, but because the way in which the court really reshaped the law of injunctions, particularly permanent injunctions, although they were trying to fix a patent law problem, may have overstepped the remedies jurisprudence. And it's a little bit ironic, because we often see sort of property law concepts being imported into patent law to solve a problem, and then they sort of create unintended consequences that we have to deal with in another generation, where different problems, particularly technological problems that we didn't foresee, might arise. So, is it your sense that that unintended consequences more generally are something that the courts are trying to manage as they identify and apply these misfits?
Yeah, I mean, I guess I don't know if there's sort of a long-term plan with respect to patent law by the Supreme Court. Certainly, they're showing more interest, and I think getting into the sort of practical, real-world consequences of different decisions, and you can see this. So I know you're talking about remedies, but in one of the other areas that I discuss in this paper, in exhaustion. So in discussing international exhaustion, whether goods that were sold abroad by the patent holder or by a patent holder who holds a patent abroad as well, whether it's an infringement to then import it into the United States without authorization. And the court said no. Once it's subject to an authorized sale anywhere in the world, the U.S. patent rights are exhausted. But in that case, and in the earlier companion copyright case, Kurtzsang, that ruled there was international exhaustion for copyright, the court really looked at what would be the practical results of maintaining a sort of only national exhaustion rule and saying that you can stop imports of goods that people bought abroad legitimately with authorization from rights holders, and said, this would be terrible for international trade. And it would be terrible for consumers in the United States who could walk around and who could go to buy the same book that looks exactly the same, but one of them has restrictions on resale and the other one that was first sold in the United States doesn't, for example. And so the court's really grappling with the sort of practical implications of their rulings on commerce and on innovation, and trying to see, if we go along with this property rights sort of strong protection rule, what is that doing for the way that third parties buy things and use them? What is it doing for the way, in the case of remedies, what does it do for the way that third parties innovate and bring things to market and do their due diligence if there's all these overlapping patents that can potentially hold them up? And so I think you're right. They are sort of fixing some of these problems that stem from a misfit, where property law usually looks at conflicts between sort of the owner of the entitlement and another person or cognizable class of people that are interested in it, whereas patents have this sort of real public interest in them. If you don't grant the patent, then the public owns that information or has a right to use it as they wish to. And so the patent law is really mediating against a much broader set of interests than I think traditional property often is.
Yeah, and the case of exhaustion is particularly interesting, as you lay it out in the paper, because in ordinary property law, sort of hornbook property law, post-sale restraints on alienation are highly disfavored. In the state of patent law prior to the Kurtzsang decision, the Lexmark decision, was that international exhaustion, national exhaustion being the rule, depending on how different territorial jurisdictions were segmented, you could have a perfectly legitimate set of post-sale restrictions. You could just impose them contractually. You could say that by buying this product, you're not allowed to re-import from another country. And if that failed, you still had this sort of backstop of actual patent infringement law, which would let you accomplish the same thing. So ironically, it seems like the court brought patent law back into line with the ordinary view of property's disfavor on restraints against alienation.
Yeah, and so I do think that's fair. I mean, I think all of these cases, you can read them through a property law lens as well. They all went against sort of the arguments put forward by those who were relying on property rights in order to make their argument. And so in that sense, I think they deviate from the property law argument. But I think you're right. There are pieces of property law and there are limitations in property law, and certainly in exhaustion. So, I mean, John Duffy has a paper, and I talk about that in the Property Law Misfit, where he talks about patent law's domain, right? And so once you've sold something, it's out of patent law's domain, and you might have a contract claim against someone if you've put some sort of limitation on them when you're in privity. But then if they, rightfully sell it to somebody else, you can't then have those restraints run with the good. If you've actually sold the thing, you can't have limitations on it, post-sale limitations, and that is consistent with property law. So I think there's ways you can read all these cases that are consistent with property law, but that's because property law is pretty big. It's probably bigger than patent law, as a field, and so sure, but then that's sort of underdetermined, right? I mean, saying that that patents are a form of property then doesn't actually tell you much more, because what you want to know is, okay, and so what limitations are on them, and when do we not have limitations, and when will those apply, and then also for, scholars, we want to talk about when they should apply. And I don't think that just going back and saying, is there some kind of, arcane form that might apply to this new modern type of field, I don't think that that's necessarily the most useful way to go about looking at patent law. I don't think it's useless, but I don't think it should be determinative if what we have before us, from the Constitution, is this idea that we want to further innovation, we want to further sort of the spread of information and have disclosure of all that information and build on it and all of that. I'm not sure what we get from property law if that's what the exercise is. It neither determines what the outcome will be or what it should be.
Yeah, so I mean that seems to me the main real contribution of your article to this literature is, up until now we've been talking in that literature about what the questions are we should ask, and what's interesting and what's useful, and which analogies are apt and so forth. But it seems like you're offering a real sort of rule of decision to know that here's when property law can be useful, and here's another set of circumstances in which the courts are likely not to think that property is really the end of the conversation. It may be the beginning, but it's not necessarily the end. And so the predictive, sort of promise of the courts, figuring out how the courts will go and how they should go, seems to be the real contribution here.
Yeah, I'm sort of a practical person in some of these terms, where I want to know, okay, it's a right of exclusion and it's an in rem right and all of that, but what does that mean, and what should it mean? And so, yeah, I hope that is one of the contributions. I think, and to that end, I think that the courts are most likely to deviate and should be most likely to deviate when we have sort of these strong third-party interests in their own possessions, in their own property rights, and when we have concerns about the clarity of the rights boundary, and the scope of the public domain, when we worry that might be that there might be an opportunity to take things out of the public domain that really ought to be in it.
Yeah. So with respect to third-party rights, and particularly, when so many third parties are involved that it's essentially the public interest at large that we're talking about, it seems to me that was as you said, the most recent and perhaps the most direct confrontation that the Supreme Court had with the property analogy for patent law, and that was the administrative post-grant review setting in the oil states case. So let's talk a little bit about that, because that's an issue, of course, that's very dear to me, as you know.
Yes.
So in oil states, the question, of course, was whether the patent office administrative adjudication system was constitutionally permitted to deal with the validity and perhaps even the extinction of patent rights if it turned out that they had been improperly granted. It used to be the province of the courts, and the American Invents Act set up all of these new administrative proceedings. So in that case, how did the property law framing, as advanced by the petitioner and amici, how did that property law framing urge one outcome, and in what way did the court take the alternative approach?
So I think that the sort of property law framing idea was that, look, these are, if they're property rights, then they are then they're protected and they shouldn't be taken away without due process and hearing in an Article III court. And so by routing them through an administrative agency, even though the decision is appealable to the Federal Circuit and then the Supreme Court, of course, but by routing them through an agency, you're depriving a rights holder of that Article 3 hearing on the extinguishment of their property right. And so the court decided, and I thought it was interesting. I'm actually, so I think it is one of the clearest cases. At the same time, I'm not sure that it's one of the cases that most fits my criterion for when the court should depart, but the court holds that the decision to grant a patent is a matter involving public rights, and say that the grant of the patent is a public right, and then the inter partes review is just reconsidering that grant, and so that's okay. It's okay to have the PTO do that. What I thought was kind of interesting is that they sort of give this idea that patents might be different things in different contexts. So the court warns that the case, quote, should not be misconstrued as suggesting that patents are not property for purposes of the due process clause or the takings clause, end quote. And so I think the idea is like, hey, if there's a government takings, then that has to go through an Article 3 court. But here we're just reconsidering the grant of a public right, and so therefore it's okay to have an agency do it. It's a little bit of a strange holding in that way, I think. And then the other thing that's a little bit strange about it is it doesn't directly engage with the situations where I say that third party interests are strongest necessarily. We don't have some third party using their own property to do something allegedly infringing and being stopped from doing that the way that we do in eBay. We don't have somebody who's bought something legitimately the way that we do with exhaustion cases, and now they're being stopped from doing what they want to do with the thing they bought from a patent holder. So we don't have these strong third-party interests sort of directly engaged the way that we do in the others. But as you and I talked about earlier, that there's a huge number of patents that were granted under different standards, and those are out there making mischief in various ways, or being made mischief with, I guess, in various ways. And so I think if you put the America Invents Act into its context and what it's supposed to do, and what Congress wanted it to do, I think it makes practical sense to have it happen this way. I just think it's very interesting to sort of say, in some contexts, we'll treat patents as one type of property, and in some context as another. And I think that the willingness to do that really sort of drove some of my thinking of this paper. Like, what does that mean that in some contexts it's property and in some not? What does that mean for litigants and patent holders, and what does that mean for us academics kind of trying to figure out what the limitations are on patents, when they are, and what the content of it, where we derive those from.
Yeah, so that's so. In closing, I guess the question of limiting principles is an important, I think, bookend to your argument, because you do identify that property law itself contains a number of important limiting principles, some of which could be, as you've said, could be applied to patent law as well, and some of which sometimes are and sometimes aren't. And so what we really need is a theory of when to use which of those limiting principles. What do you think the limits of your misfit argument on its own terms really are? What does your approach not get us? And so, I guess in asking that, I'm asking, how should somebody who reads your paper not misuse your arguments?
Don't misuse the misfit.
That's right.
So I think what I'd like the paper to do is sort of add to the set of critiques of a property law framework. I don't think I'm arguing against a property law framework ever or for anything, but I think it's sort of a starting point. And I don't think that noticing the misfit necessarily gives all the answers either. I mean, you could you could sort of make the argument overbroad and say, well, there's always really strong third-party interests. There's always notice problems. And you always have, the potential for independent invention and things like that. So why have patent rights at all? Why give them any strength? Why not rule sort of against injunctions all the time and invalidate everything as easily as you can and what have you? And I'm not arguing for that at all, because I think, there's a lot of value in patent law. It does what it does fairly well overall. And so the interesting questions to look at is where it's not working perfectly and figure out what should be tinkered with. And I think for that, the sort of framework that we have is fairly good, but could be tinkered with. And I think the cases where it's helpful to look to the property law framework probably have to do with sort of ownership of patent rights and licensing and all of the, well, so that's not really property law framework, but all of the questions about having a patent and what you do with that right, fairly well governed by property law generally. But if we're talking about cases where there's reason to worry about the public domain, reason to worry that people are sort of taking more than they ought to, or chilling the actions of third parties in ways that will sort of chill innovation, then I think we need to step away a little bit and say, okay, what are our underlying purposes? Are these doctrines serving those purposes? And to the extent they're not, how ought they to be reconfigured to do so?
Yeah. Okay. Well, Sarah, thank you very much for discussing your article. I thought it was a really enjoyable and well-written piece of scholarship. I appreciate it.
Yeah, thanks for having me on and discussing it with me.